Hi, I am an Afghan who applied for I-485 based SIV, and the case is pending for 20 months. When I can force the Fresno field office to take action on my case, it is waiting for interview for 7 months. In California district courts, there are not much favorable precedent decisions, and I definitely recommend proceeding cautiously and not filing mandamus lawsuit, not just because the pendency or time period, but because some courts there think that they don't have jurisdiction to adjudicate these mandamus lawsuits about I-485 delays. So they say that I-485 is a discretionary application. USCIS can approve or deny. And that discretion covers the timeline as well. So the court, once the court makes this determination, they say that we don't have jurisdiction to adjudicate this case and we are dismissing your lawsuit. So you may lose your attorney fees and court fees, and you might not get any benefit. Other than that, there would be no harm just filing a mandamus. If you want to try, 20 months is something you can try definitely, but the chance of success in California district courts, or mainly in West Coast federal courts, I think that they are much less likelihood of success than other circuits.
That's interesting because California is also a democratic state.
Yes,
right?
So the mandamus process is kind of tricky because it is also the likelihood of settlement, right? If USCIS doesn't want to fight the case, they can just adjudicate the application and moot out the mandamus lawsuit. However, in California district courts, they are actively fighting every single not every single, but most of the I-485 delay cases. I had a recent case where the plaintiff was approved I-140 based on EB1, and their I-485 was pending for a long time. We filed the mandamus lawsuit. USCIS did not fight it, and they re-interviewed the applicant, and the lawsuit is still pending. They did not issue the decision. It is an interesting case. But most of the time they fight with 485 delays right now. Yes.